I'll explain the definition of disability. The basic definition is that you have to have a physical or a mental impairment which has a substantial and long-term adverse effect on your ability to carry out normal day-to-day activities. And that basic definition is supplemented by schedules in the Act which explain, for example, what long-term is. So it has to last 12 months or be likely to last 12 months. Normal day-to-day activities cover a range of things. So, for example, mobility, the ability to carry or lift everyday items. When you look at whether or not someone is able to carry out normal day-to-day activities, what you do have to do is to disregard any medication that they're taking, for example, or any aids that they have. And what that means is that the definition covers a very broad range, and it covers what are often considered to be hidden disabilities. So, for example, people with epilepsy whose condition is controlled by medication. You might not think of them as being disabled, but in fact they will be. It also covers people with mental health issues. So, for example, although someone with depression may physically be able to walk, their depression may mean that actually, in fact, they can't leave the house that they live in. So, in fact, their mobility is affected. It also covers, for example, people who have autism and whose normal social interaction may be affected by that impairment. I'm going to talk about employers' duties towards people who acquire a disability. As an employer, what you need to do if someone has a disability is to think about whether or not they need any reasonable adjustments in order to enable them to do their job. So, for example, an employee may not be able to carry out certain tasks in their present employment. You may need to think about allocating those tasks to someone else. They may need to come in a bit later or to leave a bit earlier. Most adjustments that employers need to make for disabled employees cost very little, if anything. It may just be about adjusting the job to enable them to do it. It may be, in fact, that an employee who acquires a disability doesn't need any adjustments at all. They may need some in the future, they may need none. The important thing to do is to actually talk to the employee to make sure that they can do their job with adjustments or without them. If they can no longer do the job that they're in because of their disability, then you need to think about whether or not there's another job that they can do, again, either with or without adjustments. I'm going to talk about reasonable adjustments, particularly in relation to policies, practices and procedures. The Disability Discrimination Act says that as an employer you have to make reasonable adjustments to not only the physical features of your premises, so for example stairs, that kind of thing, but also to your policies, practices and procedures. And that means the way that a job is done, also the policies and the practices that you have in place, for example a sickness absence procedure. What you need to do is to look at that and to see whether or not that impacts adversely on your disabled employees or potentially on your disabled employees. The Act doesn't say what's reasonable. What you need to do is to make changes. It doesn't require you to do anything that, for example, would cost too much or anything that would be impracticable. But what you do have to do is to make the changes that you can to make sure that they don't create barriers. So, for example, if you have a sickness absence policy, then you may need to adjust it and to record disability absence separately from ordinary sickness absence. In Great Britain we have the Equality Act, and that introduced new provisions for disabled people. So we now have indirect discrimination, which wasn't extended to disability before, and we also have a new type of discrimination which is called discrimination arising from disability. At the moment in Northern Ireland you have the Disability Discrimination Act. You don't have indirect discrimination and you don't have discrimination arising from disability, which covers anything that happens as a consequence of someone's disability. I think there is definitely less protection available to disabled people in Northern Ireland as a result of this, and I think that really protection should be extended in this way in Northern Ireland to cover indirect discrimination and discrimination arising from disability. The disability equality duty in GB has made a difference to the way that public authorities carry out their functions. There's been a lot of work on the ground by disability organisations to try and make sure that public authorities take disability into account when they take decisions, not only in relation to the services they provide, but also in relation to employment. And I think it has made a difference. Trade unions have been using it when public authorities conduct redundancy exercises, for example, to make sure that they consider disability when they do this, to make sure they consider disability when they're looking at sickness absence, and also in relation to individual decisions, such as employment decisions, including dismissal. So yes, I think it has made a difference, not a massive difference, but I think certainly we've seen some changes. There is no obligation on an employee to tell an employer that they have a disability. If an employer asks the question whether or not an employee is disabled, and an employee chooses not to tell them, there may be issues about disclosure further down the line. There may be issues about trust and confidence in that employee, and that may become an issue if an employer discovers it. An employer may then say, well, you were dishonest with me, and they may try to use that as a reason for example, dismissing the employee. Now, if they did that, then there may then be a question about whether or not actually what they're really doing is dismissing the employee because of their disability. So that in itself may be unlawful. However, if an employee needs a reasonable adjustment, they are going to have to tell their employer that they need that adjustment, because an employer does not have to make an adjustment unless they know or could reasonably be expected to know that the employee is disabled. So ultimately, if you need an adjustment, you're going to need to tell the employer.